you can go ahead, start putting your questions in the comments and I will answer. But I have a good topic for you today. So, you're excited to get the marriage based green card, right? What could go wrong, right? In the midst of all of that excitement, you're now married, you're looking forward to being with your spouse, staying in the US with your spouse, or joining your spouse in the US. What on earth could go wrong with that, right? Unfortunately, this is where I have to just take that excitement down a notch to make you think about something and make you think about the future. And that's a lot can go wrong, right? And if you're not anticipating it, it means that it could be something that happens and you're not prepared on how to deal with it. So I'm here to just tell you about those things that you need to watch out for when you're going through the marriage based green card process. Because sometimes you're so excited, you're so into your spouse, you're so in love, you're so excited to move forward. You believe your marriage is real, everything is real. Why on earth do you need to be worried about that process? And the next thing I have to say here is what could go wrong? Do you really want to find out? Do you want to take that risk? So I'm going to talk to you about some of the things that you need to look out for. So I have spoken to multiple couples that have started out the same way. We're in love, we're finally together. What could go wrong, right? And they're usually calling me when that thing does go wrong. And in some cases, it's difficult to take the case because the mess has already happened, the complications are already there, the damage has already been done. And even in the case where I accepted, it's a lot more expensive. So they started out not investing in their process, not at least seeking legal advice, and then they end the process spending three times what they would have spent had they just done their due diligence from the start. So let me tell you about one thing that can go wrong. And it's that even after usually it starts with an application that's not prepared properly. The evidence isn't sufficient, or you may have forgotten to add something, or and that's usually what sets off the domino effect. Because when it goes before the immigration officer, they have already, just by looking at this application, they have already formed an opinion about what this marriage is, even though it may not be that way. You may have a wonderful marriage. Maybe, I mean, not, you don't have to be perfect as a married couple. Everybody has their issues, but it may not provide the officer with the context they need to come to the conclusion that your marriage is meaningful, it's real, that you're a dedicated couple. So from the beginning, when those it usually starts with the application being sloppy. There are inconsistencies in the application, maybe related to your residential history, maybe even in regards to your marital history. So for example, if one of the spouses, usually if it's a citizen spouse, if they got their permanent residence through a previous spouse, and now they married another spouse, and they're sponsoring that spouse, that can be a red flag, and that could set off a whole investigation of the previous marriage. So you want to make sure that you're looking out for things like this, right? If you've had previous marriages, if you've previously applied, if you've previously been denied, then you want to make sure that you get legal advice and representation to decide how to move forward. Then the other is residential history. So if you're living apart or if your address history doesn't match up, because they ask for your address history on multiple documents. And if the address history is not matching up to, say, the marriage, say you're not living, if you're in the United States as the immigrant and you're living with your US citizen spouse, but for part of your marriage, you haven't been living together, or you live together and you're on and off, that's going to raise a red flag. It doesn't necessarily mean you'll get a denial, but the officer looks out for things like this because it indicates that the marriage may not be what you're saying it is, and they start to dig deeper. So that's another thing to look out for, is address history, your employment history, because all of that tells the tale about where you've been, what you've been doing, who you've been with. And you want to make sure that even if there is some, because you can never tell a lie on this application, never do that either. But what you can do is, and this is where I come in with my clients, if there is something that's going to raise a red flag, it may be worth it to face it head on and explain the situation. For example, if you're living apart, then it's to also provide evidence of why you're going to school. Maybe one person is going to school in another state, the other is pursuing a career or an education at another state, and maybe they're temporarily living apart until they're finishing school, or they get to a certain point in their career where they can now live together. And usually that's a temporary situation. And so you may have a long distance thing going on while you sort through your situation, going to school or pursuing a career. But you have to make sure that you understand where these could create potential issues, and then that you have the ability to address these issues in your application. The other is your evidence, right? So one is insufficient evidence. Insufficient evidence, as in, I hear this a lot, right? And it tends to make me cringe. And it's like, I don't know why they didn't think the marriage was real. I gave them like 100 pictures of us together. And pictures are great, but pictures will not get you your green card. It will not get your marriage-based process approved. So a marriage certificate and a bunch of pictures will not tell the tale about your marriage. It just says that you guys spent some time together and took some pictures. They want to get a full picture of what your marriage looks like. So that means, in addition, the pictures are the cherry on top, but you also have to show the reason you are going to be together for life. How are you planning to spend your lives together? And every married couple, when you do have those in mind, you have something to show for it. And that's what they want to see. They want to see that something that you have as a couple to show the immigration officer that you do want to spend your lives together. And so if you send some pictures and a marriage certificate, for sure, you are going to either be roasted at the interview. If you're not roasted, which in most cases you're not, but that can happen, where if the officer clearly shows that they are skeptical about your marriage. But even if they don't do that and they are very straight faced, what they will tell you is, thank you very much. You'll get something in the mail. You'll get a decision in the mail. And then what you'll get is either a notice of intent to deny, a straight up denial, or a request for evidence. And nobody wants to see that, especially when the request for evidence or notice of intent to deny, that's a notice where you get a chance. They're basically saying, so the notice of intent to deny is a notice, it's not a denial. So if you ever get that, don't think, oh my gosh, I'm denied. But what it is saying is that based on what they have, they are giving you a heads up that they plan to deny the application, but they're giving you one more chance to convince them. You usually have 30 days to respond to it. If you don't respond in 30 days, sure as anything, you'll get a denial. But if you respond within those 30 days and you respond, well, that's what I do for my clients, and I have gotten approvals for my clients in situations like this. So it has been completely turned around, the situation, but it wasn't pleasant for my clients to get this. And they hired me after the fact, by the way. They hired me after to do this. So they weren't pleased because now it's expensive and now they have to sit and fret about what the final decision will be. But in cases like this, I have had it turned around. But how did the whole thing start in the first place? The evidence was not great. The evidence that was submitted with the application was not great. They turned up to the interview, and the officer already had a perception of the couple, and nothing they said at the interview changed that. And so the officer was ready to deny it until we brought forth the information and evidence that they really needed to see. So, you want to make sure that you present meaningful evidence, not just pictures and not the marriage certificate. There are two requirements, more requirements, but I want to distinguish between two types of evidence. So, one is they want to see evidence to see that you're legally married, that wherever you are, you're legally married, that it's an accepted marriage where you got married. Then the other is they want to show proof, want you to show proof that your marriage, you intend to spend your lives together, that it's real. So with the legally married, any two people can get married, right? Any two people can say, hey, let's go get married. Nobody at the courthouse to get the license is asking you about your history. Is it real? Do you really want to do this? Any two people, if two people say, I think let's buy a house together, but we get more benefits if we are married, then any of those two people can go get married and just show that marriage certificate and get the benefits as a married couple. In immigration, that's not allowed, and it may not be allowed in a lot of other areas, but in immigration, that's not allowed just to get married for immigration benefits. But they want to first see, so the first thing is to see that you are legally married, that you got the paperwork done and you went and put it in writing and on paper that you're married. Then the other is more of the lovey-dovey stuff, right? The other, you don't have to be a perfect couple. You don't have to live up to a certain standard of perfection in a marriage. But when I say lovey-dovey, it's they want to see that you two have some plans in mind for your future together. And when we talk about that evidence, it's going to be different based on what kind of marriage you have. But it's going to be something along the lines of, your finances. How are you planning to meet your financial goals and your financial responsibilities? It's going to be family planning. Do you have children, or do you plan to have children in the future? It's going to be, how do you plan to cover your tax bill? Where do you plan to live together? And also, as a married couple, do you put yourselves out there to the world that you're a married couple? So, do you meet with your friends, and do you go on double dates? Do you go to family occasions together? Have you met each other's family? And if so, then statements from friends and family talking about what they know about your marriage is also going to be valuable here, especially when you're newlyweds and you don't really have a lot yet, because newlyweds, you're just starting out. Maybe you'll have a lease because most married couples who plan to spend their lives together are going to live together. So maybe you'll have a lease, but maybe, nothing else is in order. And that's where affidavits are going to be more of a benefit. So you want to make sure that you realize that there are legal requirements here. It's not just filling out paperwork and showing a marriage certificate, but there are legal requirements that they want you to meet. And they're very strict about that. So if you don't meet those requirements, that's the first thing I see that goes wrong. And then the interview, right? Because most times everything goes well up until the interview. So sometimes there's no way to tell when things are going to go south until you get to the interview. That's where the officer then starts to sometimes they don't, sometimes they don't make it very clear. And then you get the unpleasant after effect of having to wait another year or two to be able to get your permanent residence or to get your denial, right? But at the interview, the officer interviews you, and if you're not prepared for the interview, if you're not prepared with the additional evidence that the officer needs, then that does create problems. And then just things in your history, your marital history can be a problem because it can then trigger a red flag to for the officer not only to look at your current marriage but previous marriages. So you want to make sure that you're prepared for situations like this and to address it in the application, because if not, then it things can go terribly wrong. And let me tell you why sometimes after the interview it takes very long. My experiences with all of my clients have gotten their decision and have gotten their approvals at the interview or shortly thereafter. And if that's not the case and it's been months later, even a year later, and you're still waiting, it likely means that they have spotted a red flag and they are looking into it. So sometimes they do an administrative type of investigation where they will show up at your house and visit you and your spouse to see what's going on. Are you living together? Is everything the way you say it is? They will schedule another interview with you, and then it's called a Stokes interview, and they'll go ahead separate you if they don't do that at the. So separating you is a sign that they are really paying attention here. So when they separate you, you know that things can go wrong if you're not on your toes. So separating you, but that's usually at the interview. But if they do a second interview, that's a red flag. If they take weeks or months to give you a decision, then something may very well be going on, and they may be opening up further investigation to look into whatever has raised a red flag to them. So you know, and it's sad though that at that point, it's at that point that and the couple has to seek help, because at that point it's sort of already gone in a downward spiral and there's hardly anything that can be done until either a decision is made or you get the you get the notice of intent to deny, or you may get the approval after going through all of that hell. But usually approvals will not take so long. It won't take a year, it won't take a year and a half, and it means that they're looking further into your situation and they can really put you through the ringer before you finally get something out of them about why it's taking so long. Because usually this process, so the shortest I've seen is 5 months for my clients from beginning to end. And it's really, going a year and a half is really pushing it in the marriage based process. So if that's happening, it usually indicates that there's something with the application that may not, there may be a delay in the processing because maybe the application wasn't submitted properly. Maybe there's insufficient evidence. Maybe they're reviewing going a little deeper into it because maybe they've spotted something that has triggered a red flag. So keep in mind, what could go wrong? Do you want to find out? I don't think so. So this is where you and your spouse need to invest in your future. Make sure you, at a minimum, get legal advice first. Don't assume that, hey, we're married, this is real. What could go wrong? A lot can go wrong. And if you don't want to find out, make sure that you protect yourselves. And I have told you today some of the ways that things can go south if you don't protect yourselves. And that's what immigration attorneys are there for. That's what I am here for. I would rather prefer to avoid those issues from the start than to have to fix it for my clients, because then that becomes more expensive, more stressful, and just more of a battle rather than just, being able to savor that excitement you have. You have to now be stressed out. And sometimes that can even create a burden on the marriage itself, because when you're waiting like this and nothing is happening, you're not getting a decision, you start to really have an uncertainty about your future, and that you may not be able to take certain jobs, you may not be able to move to a certain place, because now you have to be worried about what decision you're going to get or what's going to happen. And then sometimes there's this affects, negatively affects the marriage as well, right? Because the spouses can't move forward, and so you should keep everything I said in mind. I am telling you this because I have seen it, and I just shake my head when this happens, because you'll hear me say it very often on here. All right, so I'm going to answer questions. Go ahead, put your questions in the comments. I see two here. So sorry, not related to current topic, but I was wondering, you can tell me what is needed when applying for advanced parole for medical reasons. So when it's going to depend on how you're applying for advanced parole. Is it for asylum? Is it because you're a DACA recipient, or is it through adjustment of status? When you're applying for adjustment of status, it's more straightforward. But if you need advance parole and you have to give a justification, then it's going to depend on what those medical reasons are. Of course, is it someone outside of the country who is sick? Do you need to seek some kind of medical treatment, or are you leaving for a medical reason? So, it's basically to get the evidence that backs up your medical reasons. If your family member is sick in the country that you want to go to, then getting medical records and a doctor's letter detailing what's happening is going to be some of that evidence, along with showing your relationship with this person. That if it's a mother or if it's a grandparent, you're able to show that you do have that relationship with them. If you're the one that for some reason you're leaving the country for medical reasons to be able to get some kind of treatment, then you would get your doctor to be able to get that. So how long after the T status? How long after getting the T status can I file for adjustment of status? That's a great question. So with T status, it's usually 3 years after getting T status, you can apply for adjustment of status. But there is a way to get around that, to get early adjustment of status. And that's if you have worked with law enforcement, you reported it. Then after the law enforcement, and I usually keep in touch with the law enforcement agency, but after the law enforcement agency is complete with their side of things, sometimes it's not a full-fledged investigation. If you made a report, they may keep it open. And then, they may not be able to pursue it. They may not choose to pursue it. And so at that point, I get in touch with the law enforcement agency and just confirm that they have closed it and that they don't have any further inquiry. At that point, we can take that letter and go to the Department of Justice to get what's called an early adjustment of status letter that then allows our clients to file the adjustment of status based on T status early. So it's one of those things that happens in the background of my law firm when I do help my clients to be able to adjust status earlier than the 3 years. But that's how it works in a nutshell. And I take care of it all, so I don't make my clients worry too much about all of that background stuff. But there is a way to get it early in a case like that. All right. Great questions. And I'm going to go scroll through. Um, I'm going to scroll through Instagram to see. So if my spouse has a green card, can I marry him and migrate to the States? Absolutely. So if you're outside of the United States, now is a good time to do that because there is no wait list right now for spouses of permanent residents. That has not always been the case. So take advantage of it because when more and more and more and more people apply, then that wait list is going to come back. Um, So elaborate more on parole applications. So, with parole, it's going to depend on what your situation is. There's what's called, I don't know if it's advanced parole you're talking about or humanitarian parole, but with advanced parole, it's usually permission, a travel document to allow you to leave the country. And in some cases, you need to show evidence in, for example, adjustment of status. You can apply for it and the requirements are not as stringent as, say, if you were a DACA recipient or if you had asylum or another type of status like TPS. But when if you're talking about humanitarian parole, if you're outside of the United States and you need to come to the U.S. for some reason, and it could be based on, it could be based on an urgent need, a humanitarian need, then you would be able to apply for humanitarian parole. Usually, it's related to you coming here for medical treatment, or if you have family members here that you need to get to, then humanitarian parole could be the last resort if you have no other way. If you don't have a visa, if you're not admissible, then you could use humanitarian parole to get into the country. So those are the type of parole applications that come to mind. And then you do have the parole applications that they authorize for certain people who are in trouble, like Ukrainians right now are able to get a parole as well as Venezuelan citizens. All right. Keep putting those questions in the comments. I am keeping an eye on YouTube and I'm also on Instagram right now, looking over topics. Looking over questions. I see you, Ricky Flossie. So you said, love this topic. I'm glad. Joint bank account together. Yes, absolutely. That's good evidence. Now, when with the joint bank accounts, so I'll give you another tip here. When you're submitting these joint bank accounts, you shouldn't be just submitting the front page of a bank account or a letter saying you share bank accounts. You really do need to, what they want to see when they ask for joint bank accounts, they don't just want to see that you own the bank account together. They want to see that you're transacting, you're carrying out financial transactions in the bank account, because that tells the story, right? If you just send the front page of your statement, that's not telling the story. um, Okay, so Ricky Flossie has said something else. So when he was leaving the interview, the officer was eyeballing them. That's another thing. They do watch you. So they watch you when you're coming out of the interview. They watch you all the way to the parking lot and beyond. Remember, I said they can go to your house and they can ask to come in and look at your house and see if you're actually living together. So those things do happen. They're watching you in the waiting room. They're seeing how you are together. So yeah, that definitely does happen, and so you should not underestimate this process. So that's for a client that's a citizen. So no, so citizens and permanent residents can apply for their spouse. Um, so I'm gonna keep going. Thanks so much, Ricky. All right. So, what if your spouse is paying child support? Does that affect the process? No. So, no, I don't want to just say no, right? But generally, the citizen or in some cases, permanent resident spouses child support isn't necessarily going to affect the green card process. It may affect the citizenship process, but when it comes to child support, it's not going to affect the green card process. But for instance, if child support then indicates that the spouse that's sponsoring you is currently involved in another relationship or another situationship, then that can raise questions. So, they can pull all of this stuff up. They do pull all of this stuff up. And if they see that, for example, whatever is on public record indicates that while the citizen or resident spouse was married to you, they're also involved with someone else, that they can raise questions about that and even deny you on that basis. When officers do home visit, can they question young children in the home and family members? So you want to make sure that you set boundaries, right? Because it's your home, you are giving them permission to be in your home, and so you can set those boundaries. They can't force you, they can't interrogate you, they don't have a warrant. It is if you they come to your front door and you decide that don't want them to come into your home, you don't want them to talk to your children, that is within your right. They do not have any warrant that states that they are entitled to do any searches or questioning. So you can set the boundaries in regards to the officer coming to your home and where they can go and what they can do, right? Because while they're doing that, they don't have a warrant, and they still do need something like that, a legal basis to be able to, you know, if they're going to force you, that would be how they have to do it. So, you have to set those boundaries. They don't have to if you don't want to. All right. If you have a 13-year-old, should you also put in the child's paper with yours if you're being supported by your spouse? So go ahead and schedule a consultation. Yours is really specific. So that's where, as usual, another thing, while I am giving you good information, it's for your education, it's for your empowerment. It's not for you to take this information and fill out paperwork and do your own thing, because that's not what I'm telling you to do. Actually, I'm telling you to do the opposite. So if you have very specific questions, I don't review forms in consultations. I give legal advice and determine whether you qualify for me to help you. And that's where you need to start. You need to get a detailed evaluation to determine how you want to move forward and how do you want to make sure that you're protected in the process. Um, Off topic, what status can a family of four petition for if they overstayed? It's going to depend. When you overstay and you're a family of four, it's what were the circumstances that led to your overstay. For example, I've had individuals who have called me and they have been in similar situations and they thought they didn't have a way. Turns out they qualify for T status, which is as victims of trafficking, because one of the family members ended up in a situation where they worked and got mistreated, and they were exploited at the same time, and in that case there is relief. So it just depends. I wouldn't be able to just there's so many different ways, but it all depends on your circumstances, and that's another reason why the consultation is so important, because I do evaluate all possibilities here and I provide that to my clients and they make the decision about what they want to pursue. What about filing for my parents that lives outside of the United States? If you're a US citizen, age 21 and up, you're able to do this. um, if I get a job sponsorship from a private school as early childhood educator, is this a way to adjust status? So no. So if you get sponsored, it's gonna depend, right? So on the type and whether the employer. So usually the employer has to be involved in that situation to help you to adjust status. Is it better for a partner who has a green card to get married in the USA or in another country? That is definitely for the consultation. It's going to depend. Um, what if you and your spouse never live together? Is that an issue? We currently don't have a joint account either. So yes, it can be an issue, and that's where you want. That's the whole purpose of this life. So if you don't have pictures together, you don't have a bank account together, you you don't, you've never lived together, and you hardly have a reason why you don't live together. That's going to be a problem, and you want to make sure that now, some of my clients, they don't know how to present it, and they may have their reasons, and they may think, "Oh my God, we don't live together, we don't qualify." That's not necessarily true either. But this is where you need to get legal advice, because if you've never lived together but you are married and you don't have a joint bank account, then what's the purpose of your marriage? Because the officer is going to think, um, and if anybody, you tell anybody this, they're going to think, well, why did you get married in the first place? Are you just doing it for the papers? That's what the officer is going to think. So you get legal advice, because even though you don't live together, that's a hard one to swallow. The reason, the next question would be why, which I usually ask in the consultation, and then I tell you whether that reason is valid, and or whether it's going to be a big problem. Maybe you need to I don't, these are where maybe marital issues come up. By the way, maybe you're not living together because there are some abuse or mistreatment going on. In that case, you could have an option for yourself, to pursue it by yourself. But it all comes down to what kind of marriage do you have, and that's where the consultation, I have these follow-up questions. After a mother filed for her child over 21 and everything approved, what's next? Child not in the state. Uh, so if they're not in the States, as in not in the United States, so you're gonna have to wait until a visa number becomes available, and then it gets moved to the embassy for the interview, National Visa Center, and then embassy. Um, so do you take on clients after they have filed on their own? So it's going to just depend on what the situation is. As I said previously, we need to talk in a consultation. But once you have filed, that's where it's really difficult to, determine what you submitted. Another tip here is make sure you keep everything that you filed, every single copy that you filed. In cases where you do need to talk to an attorney, and that attorney can review what you filed and be able to advise. And then the other is sometimes the damage is already done after you file. After you file, the damage is already done, and there's not much that I could do as the attorney. And or I wouldn't be able to do until the immigration service actually sends something like a request for evidence. So try to make sure you do this before filing, and this is the advice with everything. Never do something first and then try to find an attorney later. Can a company sponsor someone if they overstay? Not usually. Great question. And this is sometimes where I find people end up in labor trafficking situations, because if an employer here is saying, "Oh, you overstayed, come work for me and I'll get your green card," that's likely not going to happen. Once you've overstayed, they can't sponsor you then. All right, so I'm going to call it a day. Thank you so much. Do I represent clients in every state? Absolutely. I represent clients in all 50 states and around the globe. So go ahead, give me a call. For those of you, I am based in Boca Raton, Florida, but I do phone and video consults for those of you who are not in the state or not close to me. To contact me on YouTube, of course, you see it on the bottom. You'll see the phone number. Go ahead, give me a call. Also, in the About page of YouTube, you'll see the link if you want to schedule your own appointment. And on Instagram, there's the link in the profile go ahead, use that link to go ahead and schedule your own appointment. You can do it without calling the office, and you'll get everything you need to move forward. So thanks again for your time. I hope I've given you some valuable information to consider. Remember, protect yourselves. You don't want to find out the hard way about about what could go wrong, right? Make sure, and I will save this. And I'm so glad. I can't wait to speak with you in that consultation. And I do save the lives, so go ahead. And Ricky Flossie, always good to hear from you. You are welcome. Thanks so much for your time, everyone. Bye bye.